Good afternoon, everyone. Welcome. We are having today's webinar, which is a very important topic. So the society has organized this specifically for all the members. And you can see that in our panelists, we have with us Justice Anuka, former Chief Justice of Bombay High Court, and Justice Gupte, former Judge of the Bombay High Court, and Farzana, the past president of BILS, and me. And we have our friends here to help us with some technical part. It's Bhavik Petta and Gurveer Singh. So today, the topic that we have chosen is the effect of the repealing of Section 213, which required probate, which was a section where probate was in the towns of Bombay, Calcutta, and Madras within the original jurisdiction of these three courts. And now that it is repealed, what is going to be the effect? There are a lot of questions that we have received from the members. We have collated those questions, and I and Farzana are now going to put these questions to our panelist judges and take their views on that. So I'll now request Farzana to take over.
Good afternoon, everyone. We have, as Nilesh said, Section 213, which has got repealed. As Nilesh has already mentioned, this section applied to Hindu, Buddhist, Sikhs, Jains, Parsis. Probates were required with regard to wills made in Bombay, Calcutta, Madras, or where properties were situated in Bombay, Calcutta, Madras. The repeal of this section has resulted in questions, as Nilesh said, and I would like to ask Justice Gupte, what, according to you, sir, are the broad merits of the repeal?
Yeah. Before we do so, let's have a quick round of what the legislature has really done. As you've been told, the section 213 is repealed. That means the mandatory requirement of probate in cases of two classes of wills has been now done away with. It was for wills made by Hindus, Buddhists, Sikhs, Jains, Parsis, as she said, and it related to either wills made within the original jurisdiction of these presidencies on the one hand, and wills made anywhere but relating to properties which are situated within these three jurisdictions. So that is removed, done away with. Secondly, it removes the reference to Section 213 in two provisions of the Indian Succession Act, namely Section 3(1), which provides for the state's power to exempt any race or caste, sect from the application of certain provisions which included Section 213, and it removes the reference to Section 213 and Section 370, which dealt with the restrictions for issuance of a succession certificate. Wherever the law required wills to be probated, in those cases, succession certificates cannot be issued. So that is also now taken care of by removing the reference to these two sections. Now, the objects are said to be to remove discrimination and establish a uniform testamentary regime. Now, this discrimination was obvious. This distinction was really speaking arbitrary. It had no logical basis. Why wills only within the jurisdiction of three presidencies, and why this geographical location of properties or testators? So, yes, no, okay. So this discrimination, which was dependent on the testator's religious identity or the geographical location of the testator and the properties bequeathed, so that is done away with. That was the sole objective of this amendment. Secondly, even for unprobated wills which were not contested, people had to go to the probate court and seek probate. So spend for probate, take the trouble of going through these proceedings. And as I am told, it used to take at least about a year to do so. So it will basically, it does away with, I mean, in a good way, the obligation to seek probate for uncontested wills, A. And it is expected, as is a natural consequence, to hasten up the process of transmitting interest in properties. On the other side, if we see some demerits, you see, the very fact that there is a reduced court oversight, I mean, it may lead to a greater risk as to the manipulations and malpractices, because it was a kind of a filter the court had by way of a probate application. That is now gone. Of course, anywhere in the country other than these three presidencies, it was never there. And yet, to be sure, it has not created any big problem as a result. But in any event, Mumbai properties are really special in that sense. So this reduced court oversight may lead to some greater risk. That's one. And these risk implications are for various stakeholders, like the beneficiaries themselves, because their title is never certain. The purchasers, the financiers, on the strength of what document do they now act? Do they accept a will which can later on be declared to be invalid, etc., etc.? So these are some of the major issues. Earlier, when the probate court used to grant probate, it used to be an order in rem, so that the world at large is bound by it. It is no longer so, because now any determination relating to validity of a will is a determination in personam. So the difficulties which are attendant on this particular determination are bound to be there. So that is how it is.
Sir, Justice Anuka, if I may ask you, with section 213 having been repealed, would you today recommend that an executor who is appointed under will, he may be a relative, he may be a non-relative, should he apply for probate? How does an executor, under the Act, rights vest in an executor pursuant to being an executor? He's entitled to deal with the estate without probate. However, today with the repeal, do you see a greater risk of an executor acting without probate because he does not know if some beneficiary, somebody else comes up and challenges the will? So would you recommend that probate be applied for?
The amendment of 2020, it is optional. It is not compulsory now not to apply. My advice is that you have to apply for various reasons, because only 213 is repealed. There are several other provisions which still require for obtaining probate or letters of administration for various purposes. Unfortunately, there is no consequential amendment to those provisions. You must have seen at more than 50 places there is a reference of probate and letters of administration under the provisions of Indian Succession Act. So what happens to those provisions? This is not a case of repeal of the entire act. This is a case of only repeal of section 213. Take for example 214, and for your benefit, where court can pass a decree against a debtor of a deceased person for payment of his debt to a person claiming of succession to be entitled to the effects of the deceased person or to any part thereof. So no court shall pass a decree, though executor would have filed a suit for recovery of the dues or debts to the deceased testator. A decree could have been passed only after such probate or letters of administration would have been granted. Now, this provision is not amended, unfortunately. So the effect of that is that if any suit is required to be filed by the executor or the legatee, in that case, for recovery of any debts from the debtors of the deceased, unless he produces one of these documents, he will not be able to maintain any suit. So similarly, there are other provisions also where this refers to the requirement of probate or letters of administration. One of the important provision I would like to share is 273, where what is the effect of probate? Probate or letters of administration shall have effect over all the property and estate, movable or immovable of the deceased throughout the state in which the same is or granted, and shall be conclusive as to the representative title against all debtors of the deceased and all persons holding property which belongs to him, and shall afford full indemnity to all debtors paying their debts and all persons delivering up such property to a person to whom such probate or letters of administration have been granted. So the effect of probate was that it is conclusive in so many respects, unless of course there is a title dispute raised subsequently by some of the parties. In that even separate suit was required to be filed by the executor or the legate in that case. Otherwise, it was all conclusive and action in rem. Now, if you are not required to obtain probate, then what happens? You apply for transfer of your property in the records of society, or you go to a bank, or you want to apply for mutation entries. In that event, all these authorities will insist for grant of probate or letters of administration, bring it, otherwise we are not concerned. Because there may be rival claims, how to protect their interest. In that event, ultimately, you will have to file a civil suit, either before civil court, or you apply for some such relief before the district court. So, in my respectful submission, there is hardly any benefit granted by this. It is only a matter of satisfaction that we are at par with others now. Muslims and Christians were not required to obtain probate. Others were required to obtain probate. So Article 14 is dispensed with by virtue of this amendment. Otherwise, I don't find any benefit of this. You are still required to follow some proceedings. If not, you are not before a probate court. You may be before a civil court. I don't find any benefit. I feel that one must apply for probate, even though it is dispensed with, it is optional. There will be a number of benefits. You can file citation, so citation on the legal heirs. Then there can be caveat. The person should have caveatable interest. Otherwise, if your caveat will not be entertained, court will have complete scrutiny of the rival claims. Even before granting probate, there is a procedure of service on the High Court notice board. Citation is put up so that others also who are not aware of the petition, they can come to the court and apply for objection to the grant of probate. One of the legal heirs may be abroad somewhere. He may not come to know. So of course there is a power for grant of revocation of probate under section 263 of the Indian Succession Act. But if it is before probate court, it can be granted easily. If there are legal heirs who are willing to give consent for grant of probate, they can file consent affidavit. Civil court will not have any control over all this. Even some third party also will come. He may not have a claimable interest. You file a civil suit, he will say that no, property belongs to me, or I am creditor, or I have some other vested interest. So my opinion is that you must go for probate. That will be more faster and convenient.
Justice Dhanuka, further to your saying that
Yes.
we should apply for probate. I have a live instance of executors having filed for probate. We have two challenges by two individuals, or both of whom are not related to the deceased. One claiming under a later will and one claiming under a fourth codicil. Now, in that scenario, don't you see a potential risk of wills and codicils being fabricated? We are, of course, defending those proceedings. We have section 340 for taking proceedings. In fact, in one of them, an order has been passed initiating 340 proceedings against that person who claims that he has a will. Do you not see the chances of fabrication of wills increasing? Anybody who has today can fabricate a will. He may be the moment he knows that this person has died without heirs, and this happens normally when there are no direct heirs. So if a person has died issueless or without leaving a spouse, there are lots of these people who are like trained litigants. And I'm saying this from experience that this one person who has applied in this current matter has also applied in another matter of mine. One through his wife, one through himself. Don't you see the chances of fabrication increasing? That on the basis of a fabricated will, they go and apply to some registrar, to some society and say, I am the holder, before even the executors or the heirs become aware and transfer property. So how would you look at it and how would, what is the benefit of 213 being repealed? I don't see any benefit.
No, I fully agree with you. Because there are chances of fabrication because there is no check. If you are before a probate court, there will be full scrutiny. There may be contested will, there may not be contested. If there is no contested will, affidavits of consent will be filed. Otherwise, it is very difficult. But if public notice is issued, then some more people may come before the court and they may challenge. Then there will be, probate petition will be converted into a suit and the court will have a full check on evidence only, court will grant probate. But in this type of situation where it is completely dispensed with, you may choose, you may not choose. The person who wants to fabricate, he will not apply for probate. He will rely directly on the document, fabricated document for transfer of property in his own favor. And it becomes very difficult for the authority to give benefit to that or not. What will authority do? How does he know how many more people are there, whether will is fabricated, not fabricated? He has no machinery to check that. Whereas if it is a before court of law, then of course court can appoint somebody to assist the court as far as fabrication is concerned, or more evidence can be laid. For authority before whom you make a claim on the basis of fabricated will, he will have no check to check the credentials or authenticity of the will.
So I would put it that Justice Gupte said that in other jurisdictions probates were not required. So now why are we making such a big deal about the fact that in Bombay, Calcutta, Madras, probate was compulsory required, now it's repealed? In that sense, equality has been now, colonial mindset has been changed, etc.
See, want of probate in other jurisdictions has not created some kind of havoc or something. Yeah, we've lived with all these provisions. But of course, the Bombay properties and testamentary dispositions have a special significance because of their large value and all that. And secondly, the profession is accustomed to conducting itself in a particular manner. So that has fundamentally changed. So now we need to have a look at what kind of protection, etc. now should be important. So, and I believe that's the whole purpose of today's panel discussion.
We are hoping to get tips from both of you.
Yes.
So my question to Justice Gupte in that same context is, what would be the safeguards to prevent the assets and estates of the deceased being transferred to some unscrupulous individuals? And suppose if the will is not probated, how would the title of the property be established with certainty in favor of the beneficiary or prospective purchaser?
This is something very important for the profession to really apply its mind to. You see, as far as ensuring this, avoidance of unscrupulous manipulations, etc., there is no way you can do it except possibly to have your transmission registered as soon as possible on the basis of a will. But when the will is prepared and it is propounded, there are certain steps which may have to be taken, and these are something which we should really take into account. As we all know, under the Principles of Evidence Act also, it is always the propounder of the will on whom does the onus lie to prove a will. And its genuineness really involves three particular aspects. First is the execution itself, that it must be shown to have been duly executed. So the signature of the testator is very crucial. Secondly, his disposing state of mind, that is important. The second aspect of genuineness. And the third aspect, of course, is absence of any vitiating circumstance, any vitiating circumstance which affects any inter vivos acts like fraud, coercion, all those things. So absence of those. These are the three aspects on which we need to be certain. And to ensure this, we must take in the change scenario certain steps. Like supposing it's a signature. I mean, the profession is of course free to invent and come across and find more and more innovative ways of ensuring all this. But say, for example, when we are concerned about the signature, then you have to, maybe you end up collecting specimen signatures. Maybe you also have a handwriting expert's opinion in a case where you anticipate some kind of trouble. Like the disposing state of mind, you should now insist on a doctor's assessment. And besides the doctor's assessment, there could be other circumstances like the deceased has carried out certain acts, etc., etc. So keeping a record of all that. Thirdly, it is absence of any vitiating circumstance. So that you have to have statements and declarations on oath by the other legal heirs. And this could be immediately when you read the will, firstly after the death, when the will is read. At that stage itself, you could maybe collect these statements if the will, because in most of the cases, I mean, in a majority of cases, the wills are not contested. After all, we only come across cases where there is a real contest, and those are few compared to the overall number of wills. So all these steps may have to be adopted by the fraternity. I think these are very important to ensure that the genuineness is kind of assured.
I will just add to this suggestion of my brother. So, if it is possible to take consent of the other legal heirs on the will itself, either they can be made signatory to the will as witnesses, so that to that extent at least they will not be able to challenge that will before the court of law. Of course, if
But
somebody is
many times-
excluded, he may not like to be witness or give consent. But whosoever are available and they are willing to give consent, they are satisfied. And father or mother has given his property according to his wish. He should not ask for any claim. So then it will be easier at least to that extent. That is what I feel.
But then they
But
will
then
know the
they- yeah.
contents of the will.
And
So
secondly,
maybe,
I mean, secondly, in respect of some of the properties, they may be the beneficiaries. So
Yes.
then they can't.
They should be
yes.
satisfied. If they are not satisfied, then of course they can challenge.
No,
Yeah.
in Mohammedan law,
Not everybody to give
for
consent.
example, in Mohammedan law, only 1/3 can be given by will. But if you want to give more than 1/3, then consent of the heirs is required not only before when you make the will, but even after death,
Right.
both. So something like that. But my suggestion, there was something which came to me just now in mind, that can we do a video recording
Yes,
of the
even a
execution?
video. Correct. Even
So
a
that
video
then-
recording would be one way of kind of ensuring that
That
the
evidence is
genuineness
available.
is, evidence of that genuineness is available, especially in cases where large number of properties, very valuable properties are involved, or you anticipate some kind of a challenge, legal challenge at a later
At
date.
least that undue influence and voluntary
Correct.
mind and all that can
Yes,
be.
Or most of the wills should be registered as far as Bombay is
Yes.
concerned.
In fact, I
That is
was
the
going
best
to
solution.
even suggest that the registration should now be insisted upon by solicitors.
The
Yeah,
only
we-
difficulty arises is when it's a very old testator and an unwell testator, means physically unwell, mentally completely sound, not able to visit the registrar's office, and may not have a very huge estate. To get a
Yeah.
registrar to his residence
Correct.
would be like 50,000 to a lakh as charges. This is the reality of the situation.
Yeah.
He's not supposed to charge,
I-
but this is the reality of the situation. So in those cases, it is difficult.
But it is always a strategic decision.
Yes,
Depending on if there is hardly, it's a one
Yeah.
item of property, there's hardly any dispute, then no difficult.
consent is the best, but what happens is parents sometimes are reluctant of letting their children know,
No,
especially if there's an unequal division. Then we come across the situation where suspicious circumstances, which is normally,
So therefore,
one child.
Your
comes out.
recording would be the best, where everything can be seen, there's no.
Then you have to have the
suspicious
testator
circumstance.
speaking.
Yeah.
Yes.
I don't know whether there is any provision under the Registration Act. The registrar, if it is not, can be given power, whether the testator is of sound and disposing mind when he comes to his office for registration.
No, so I'll tell you, I have got registrar relatives to me as an attesting witness. And the only thing that the registrar asked was, ये आपका signature है, you have signed it. Bas, that was all. He never
No,
asked any
and one
further
more thing.
questions.
But really
So,
speaking,
And you have to give the
really
doctor's
speaking, it
signature.
is only
You have to
the
attach a
signature.
doctor's
Really speaking, it is only the
Signature.
signature which is
And his
then.
presence in the office of the
correct.
sub-registrar itself is an evidence that that person has gone.
But the
Yes,
testamentary
that was-
capacity, this disposing state of mind, all these are still open anyway. So,
The biggest challenge is suspicious circumstance.
Yeah.
You are living with one child. Most of your assets have gone to that child. Why is the other being left?
correct. So when we really take into account what care the draftsman should take, probably this would be an important element. That, if there are any suspicious circumstances, where if there is, the testator has 3 children and he's giving most of his estate to one, then that circumstance itself needs to be explained in the will.
Correct.
Why am I doing so?
Yeah.
That I have, for example, provided enough for my other children, or that they don't need. Also, the justification can come in the document itself.
Absolutely.
So that is one way of ensuring that, the
We have
correct
learned through litigation.
circumstances.
So
Yes.
now, when we draft bills, we tell clients that no, you have to write why you're leaving out somebody or whatever.
My question to Justice Gupte in furtherance of this is that earlier the procedure was that, once we get the probate, we used to make a deed of transfer to transfer immobile properties and then register. It is a formal transfer where the stamp duty is also minimum 500 rupees. And then register that, and on that basis, the land records, the property would get transferred. So the sub-registrar's office, the land records office, even societies for that
Would
matter,
insist on probate.
would insist on probate. That
Correct.
they would always say, no, probate has to be there, then only. Now, since it is not compulsory to obtain probate, what do you think would be the reaction of these officers? Will they still insist on it? Because they sometimes say, we are not aware of all this. And
Yeah, I know.
whether,
Yeah, the actual reaction of these officers is a speculative matter, but the legal reaction, which should be there and which can be enforced, is that they are now bound to accept an unprobated will as the basis for effecting transfers. That is for sure. And in fact, we have a very, very latest Supreme Court judgment on that. It is the case of Tarachandra versus Bhawarlal. Incidentally, this judgment is delivered on 19th December 2025, the very date on which this amendment came. Of course, it doesn't consider the amendment. But the point is, this case was under the MP Land Revenue Code of 1959. The argument was that if this is by will, there is no record and of any court authenticating it, and we will not accept transmission on the basis of this will. The court said no. Firstly, the court said the code recognizes acquisition of rights through a will. So does every code relating to transmission of interest and land records, etc., etc. So these codes recognize acquisition of rights through a will. Then, if that is so, the Tahsildar or the revenue or survey authorities are bound to act on that will, particularly because any mutation is really speaking for fiscal purposes only. It doesn't settle the inter se rights between the stakeholders or the determination of title per se. So why should the authorities not act? That's the rationale of Supreme Court judgment. It in terms says so in its order. So, and secondly, it says wherever there is no dispute raised by any legal heir, any natural legal heir, then the mutation has to be effected based on that will. And if there is any dispute to be raised, then it is for that party to go to court and seek an appropriate adjudication. Why should the authorities not act? There's the very clear judgment of the Supreme Court in Tarachand versus Bawarlal, Justice Manoj Mishra. So I think the registrar and all authorities are bound to act on an unprobated will in the event of a transmission being sought.
So just before Nilesh asks you the next question, and from taking from this judgment what you have said, I have a case of a Muslim will where probate is not required. However, when we are trying to transfer property in the interiors of Maharashtra, the Talati has landed up and said, okay, you prove that you are the daughter, you prove that you are the wife, you get me a certificate from the Tehsildar or Talati in Bombay saying you are the heirs. The Tehsildar Talati in Bombay write to him saying that we don't have any power to investigate who the heirs are, and the man is refusing to transfer. As a result, now we are forced to go for probate. So in that situation, what can be done?
No, see, it's like, I mean, you have to go to
That
court
is-
ultimately
sorry,
because
sorry.
it's like a currency. If you don't accept this paper as a rupee note, then I suppose one has to go to court and get an order.
Sorry, but I differ here because this is a case of intestacy. We are
No,
talking
there-
about
Intestacy.
so
No, I have a case of a
then there is no question of he asking at all whether
Correct.
are you the daughter or son or whatever, because whoever is the
Yeah.
beneficiary name should
Yeah,
get it under
yeah.
the will. That seems to
But
be the
correct.
judgment.
Yeah, but that's why I opened this with this preface that what the authorities will actually do is a matter of speculation.
Yes, sir.
But what are they legally supposed to do? That is our
So
concern.
as per the Supreme Court judgment, he is supposed to
Absolutely is bound
transfer
to,
it
is
to
bound
the
to transfer
beneficiary.
it. Correct. He's bound.
And considering that he doesn't need to go into the authenticity of the will, whether it is
Correct.
genuine
In
or-
fact, he does not determine anyway that issue.
Yes.
That's why the Supreme Court said this is for fiscal purposes. Why is he transferring in the record of rights for these purposes? That transmission does not settle the matter of
That is,
that title.
we're under Maharashtra Land Revenue Code,
Correct.
section 157 is not conclusive.
Correct.
So
So
it's title is to, there to be.
even as evidence, it is prima facie evidence of your title. That's very clear.
Okay, so the next question is that if the will is no longer required to be probated, do you see the potential of conflicting findings by civil courts?
Yeah, technically, yes, there is a possibility because this possibility is always there. Naturally, because the decision of a probate court, as we discussed earlier, is a judgment in rem. It is binding for the world at large. And even in the Evidence Act, we have section 41, which talks about the relevancy of certain judgments of in exercise of the probate jurisdiction, the matrimonial, the admiralty, and insolvency jurisdictions. So these determinations under section 41 settle two things. A, they settle any question as to a legal character. So if your character as an executor or as a beneficiary is finally determined for the world at large by that judgment by the probate court, and secondly, it settles finally the question of entitlement. That is to say, any bequest that I am entitled to this property, that is finally settled. So the character and entitlement are finally settled by any determination. That's section 41. In any event, even otherwise, as the law would know, these are all judgments in rem. But not so when it comes to a civil court. Any determination by a civil court is between the parties, so it is in persona. But that is why I said technical, because though this is so, in many of these cases, the rules of res judicata would still apply. Why? Because, say, for example, if it's a contract between a claimant to an estate by virtue of a will and his purchaser, and if that is questioned, naturally the validity of the will be one of the issues. To a litigation like this, the other heirs are likely to be joined, and if they are not, it is advisable for solicitors to see that they are joined so that there is a determination. Now, so anyone who claims through the purchaser as well as anyone who claims through either of these legal heirs is bound by that determination. So, in a sense, many of these cases will still go by the rule of res judicata. Though, of course, and then even those who claim by way of intestacy, because once the validity of a will is proved, then that is something which will always hit them. Though, strictly speaking, there could still be a question between another party altogether, or somebody who is setting up a rival will. Even there, I mean, there could be a possibility of a conflicting decision. But in most of the cases, there won't be a palpable likelihood of there being many conflicting decrees. And anyway, this regime, as we all know, was existing for all wills everywhere in the country except these three presidencies. And it has, as I said, has not created any havoc.
There will be a situation where there are two properties of the deceased estate. So one party files a suit in some state where the property is situated. Another party will file a suit in, say, Maharashtra, will files in Uttar Pradesh. So in collateral proceedings, of course, the person who is relying upon the will have to prove that will. So on evidence, one court may find that will is not proved.
Correct.
Another court said
That
evidence
possibility
may
is
say
there.
that will is proved. So that is one part, and secondly, title issue. Because probate court ultimately does not decide the title. If there is a dispute, you will have to file a civil suit for adjudication of title. So in that circumstances, there may be possibility of conflicting decrees.
Correct.
In light of this, Justice Dhanuka, it's the same issue that we are discussing, that probate is in rem, whereas a civil court is in persona, judgment of civil court, and there may be a chance of conflict. So, considering that, how would you consider vested and concluded rights, the Indian Succession Act, which will be affected which can be affected by an unprobated will?
In my view, rights which are already vested before this amendment came into effect are not affected clearly because of the provision itself under Repeal Act Section 4. If you see, all vested rights are protected. Apart from that, Section 6C particularly of the General Clauses Act, also all these rights are protected, and the fact remains that this amendment applies with prospective effect and not retrospective. So concluded rights can't be reopened because of the amendment. Even if probate is not required, one can't say that whatever has happened now, probate is not required. So this issue can be reopened by filing parallel proceedings or collateral proceedings.
Therefore, suppose there is a transferee, a bona fide transferee of a person who claims under the will he has transferred, and there is a transferee who is a bona fide purchaser. His rights would not be affected. That's what you are trying to say.
No, you see, if it is governed by unamended provision, then merely on the basis of will you can't transfer the property. Unless will is probated, it is given effect, subject to the title issue. Title issue may be independently decided by civil court. In view of Noda versus Birla was the famous judgment which has been subsequently followed by our courts and other courts. Title issue can't be decided. So if you transfer the property only on the basis of will prior to the amendment, that has
No, after the amendment. After the amendment, we are saying that now that the 213 is repealed, we don't require a probate. So if a person proceeds and transfers the property on the basis of will,
Which later on
property
turns
would
out.
have vested in the
that
beneficiary.
no, that can be opened, of course.
Yes, because
That can be opened by civil court.
correct, because you see, it is no longer open to the person claiming to be a bona fide purchaser for value without notice to say that I will disregard title. You see, it's only when a prior right or a superior right is claimed by someone that the argument is open to him that I'm a bona fide purchaser for value without notice. But if he is a transferee from a person who has no title, then there is absolutely no defense available.
Then
in
some
any
state
event.
civil court will have to decide.
But sir, in those cases where there is a will, a beneficiary inherits by the will, he gets title through the will. Probate is no longer required. That beneficiary then, like Bhavik was telling us just before we started this panel discussion, that he has a case where one brother transfers the property to himself in the society records. He promptly gives it by a registered instrument to his children. And then if the children go ahead and sell it to a person, there's a registered instrument which is a title. It has passed through a will, it's passed through a title. By the time the other beneficiary decides to challenge the will,
But if the original transfer itself is declared void, then all
Then the
subsequent
effect of the
transfers will be.
subsequent transfer.
so how is a bona fide purchaser for value without notice? Because
He takes a big
what is
risk.
the investigation that transferee can do to secure himself?
All investigations which is done by the bars and solicitors, search of title, inviting objections, indemnity, all those things will have to be taken care of. Otherwise, it's taking a big
So
risk.
relying on a registered document is not longer sufficient.
Yes.
The next question to Justice Dhanuka is that if there is a case that in a suit, earlier suit, that suit is dismissed for want of an executor beneficiary establishing a right under the probated will. Would such executor or beneficiary be now able to seek restoration of such suit or file a fresh suit or act under the will nevertheless?
If his suit is dismissed on merits, he is not able to prove because of whatever reasons that he was executor or he was appointed as executor, or a legatee comes to court for letters of administration for some reasons. On merits, if it is rejected, prior to the date of amendment, there is no question of he taking a different position after amendment. His rights and remedies are concluded prior to the date of amendment. Question of review, yes, if it is, he satisfies the grounds under 47, then it is a different situation. Clearly, because amendment is there, whatever rights are established, concluded, proceedings are over, that cannot be reviewed.
Justice Gupte, if I may ask you. There are sometimes multiple executors appointed. All of them don't immediately apply for probate, but reserve the right to apply for probate. If a probate petition has been filed, can an executor who's reserved the right to apply for probate, once probate is granted or otherwise, say, now I don't need to apply for probate, I also want to be a part of administering the estate? How would that happen? And if probate is not applied for, can a person who's reserved his right and one executor started acting in both scenarios, where probate is applied for, where probate is not applied?
My personal view is, of course, this will be a debatable issue, but my personal view is that there won't be any requirement for him to seek a probate later, even if he has reserved his right to be an executor, to accept the executor's office. That is because, if you see the saving clause, it clearly states that the amendment has no effect on either the validity or invalidity or effect or consequences of any right, liability acquired or incurred, or any remedies or proceedings in respect thereof. So when a person says that I will decide to accept the office later and I may apply later for a probate, does not incur any liability according to me, which gets finalized as a result of the amendment. So the saving clause does not save that as a liability already incurred by the executor. That's my view. Of course, this will be debated in court.
I'll pose one question which we can discuss. There may be a situation where an executor who is allowed to file a suit for recovery of the debts, and debtors have to pay something to the testator. He died. So probate is taking a lot of time. He already files a suit for recovery of debts under 214. 214 says the decree can't be passed unless letter of administration of probate is produced. So there it goes to the court and says that I am applying for probate but entertain my suit, don't pass a decree. And thereafter this amendment comes, then what happens? Then he says that now amendment has come. So you go ahead with the suit, I don't have to produce any probate.
Correct.
In that type of situation, what happens?
In my view, he can.
He can,
He can proceed because now that the requirement is done away with, he can, according to me.
The
But
two-
as I said, this will be debated and there will have to be a judgment. Unfortunately, Justice Dhanuka is not there now to give that judgment. So, but yeah, according to me, you see, this is not a liability which is incurred.
Yes, but
So that it is saved.
214
by-
is still applicable and it says that
Yeah,
you
but-
get a probate.
But
So,
then it is not only probate. You can have a succession certificate. You can have even succession certificate is one of the
yes.
testamentary.
So when there's a will, you can't apply for a succession certificate. You can apply for a succession certificate only when a person has died in place.
Ah,
So that problem is not solved. We either apply for
Correct.
probate or letters of administration with will annex.
and the property which is already part of matter of administration or probate,
let us see.
you can't go for succession for that property. That is going to be
No,
prohibited.
214. Let's have a look. This is interesting. Okay, it talks about various other things, but most of these things are
Recovery of debts.
recovery
Yes,
of
and
debts
decree.
in the case of intestacy.
That's
But it also says probate. Probate or administration or succession certificate. So that's a very pertinent thing. And then what if probate has been applied for, obtained? Repeal comes in December 25. And the executor who's reserved his right says, now I want to also administer the estate. I didn't want to do the hard work of getting probate.
Correct.
But now I want to be a
No,
part of
yeah, yeah. This is one.
Will it
like-
apply retrospective?
The
in that
214 being left as it is indeed a lacuna, and that the legislature will have to
Yes.
rectify. There's no doubt about it.
No, let me answer your question. 214, once he has already filed the suit for recovery, then amendment comes. Then he says that I don't want to apply. Or he gets a probate. So all his rights, obligations, duties will be governed by the unamended provision. 213. Then he can't say that half obligations I have complied with, remaining half where it comes to my duties to collect the assets and distribute the liabilities, these legacies. That can't be done. Once you fall under the unamended provision, for all purposes, according to me, they will continue to be governed. You can't pick up something from the unamended and something from the amended.
So just let me ask a corollary to this.
Yes.
What is the date of application? The repeal does not apply retrospective. Suppose the deceased has died before the repeal, but probate has not been applied for. Can the executor therefore say, I don't have to apply for probate? Or can the executor who has applied for probate say, I can now withdraw my probate petition?
That is one of the questions, but I'll deal with you directly. Please see section 6C of the General Process Act that concludes this issue. Effect of repeal, I'll read 6C. Where this act or any central act or regulation made after the commencement of this act repeals any enactment either to made or hereafter to be made, that unless a different intention appears, the repeal shall not, now see, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. And any such investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and any such penalty, forfeiture, or punishment may be imposed as if the repealing act or regulation had not been passed. So, my interpretation of 6 is that his obligation to file a proceeding prior to the date of amendment was already there. Merely because amendment came and under the amendment, probate proceedings are not required to be filed. But since obligation had already accrued prior to the date of amendment, he is bound by the obligations, even though.
So therefore, if a deceased has died before the amendment, you are required to apply for probate.
I have I have a different
No,
opinion.
please tell us.
Because according to me, this is not a liability incurred by anyone.
No, I am on the obligation.
No, even there is no obligation.
Obligation, if you see 6C, so if
Yeah, but even an obligation, according to me, will be in the nature of a liability, which is incurred or accrued. So, see, because when does section 213 kick in? When the rights are sought to be claimed, no, to the estate. So, on the date when the rights are sought to be claimed to the estate of the deceased, if the provision does not exist, then there is no liability on the person to seek that.
the question that will arise is that remedy available or required to be exercised on the date of amendment or on the date of the deceased.
That needs to
Date
be
of the
clarified.
But it is always
Because
according
it is
to
a,
the
it will be a.
date when it is sought to be enforced, is sought to be claimed.
I'll tell you, I've taken a different view, but it was under Arbitration Act. I must share with you that. There, under the Bombay Stock Exchange bylaws, there was an award given by 3 members tribunal. And there was an application filed for correction under section 33. By the time the members corrected that order, it took 3-4 months more. And then when appeal is filed, there was delay of 2 days in filing appeal. The power to control delay is vested prior to the date of amendment was placed in service by the other side, that now there is no power to control delay. When you filed your appeal before the appellate bench of the stock exchange, there is no power. So appellate tribunal rejected that application for condonation on the ground that now you have filed appeal. As on date, we are not. So the view taken by Bombay High Court there was that what was your remedy available on the date of award? In this process of filing an application under section 33 of the Act, arbitrator took some time. So if arbitrator would not have taken time, then you were entitled to apply for condonation of delay on the basis of remedy available on the date of filing award or on the date of filing your arbitration application. What was the remedy available against the award? So that will apply, and the appellate tribunal can't say that as on the date of filing appeal, we have no power, we can't condone. So your remedy and your rights already approved or established prior to the date of amendment will continue to be governed, though this right is taken away by virtue of amendment. It is
So
reported
in
that
light of that,
Marwadi
I just-
shares name of the judge.
Yeah, this will have to be considered.
Yeah, so in light of that, my question was under 213, the words that were used earlier before the amendment was that no right as executor or legatee can be established in any court of justice.
Correct.
Unless the court of competent
Correct.
jurisdiction
So-
issues.
Correct. So when you go to the court to establish that right, what is the law on that date is according to me relevant, not because otherwise the law is acting retrospectively or rather retroactively also in this case. If the it applies to the testator's will or testator's death, then it acts retrospectively. Not on the date when the right is sought to be established in a court of law.
So therefore, even if a person has died earlier
Correct.
or yes,
It is immaterial.
he has died later,
On the
but
date
left a
when
will
you are
earlier.
seeking to claim those rights, what is that should apply accordingly.
What happens to a person who has already filed for probate? A petitioner has gone, filed for probate, the executors have filed for probate, and then because there is an amendment, they say, okay, we don't need a probate, so I'm going to withdraw it. Can he do that?
I don't
Will
think
it
you
be-
can, I don't think you can do it simply on the proposition that the amendment applies with prospective effect. So it will not affect the pending proceedings. Again, we go back to section 4 of the Repealing Act and section 6 of the General Clauses.
So from a conveyancing practice, Justice Anka, solicitors follow a certain practice when they act for a purchaser. So they will raise requisitions on title. They will give public notice. They will take inspection of the title document and generally try and ascertain. If there is a title flowing through a will, they will ask for probate. But in instances, there are beneficiaries, executors who say, no, I do not want to apply for probate. I'll get you consent of all the heirs. And very often purchasers will say, I don't want to wait for 10 months, 12 months for probate. I'm willing on an indemnity, on a declaration, etc. Now that probate is no longer compulsory required. From the purchaser's perspective, how does the purchaser secure himself? Because a beneficiary may turn around and say, I'm a beneficiary under the will. This property has come to me. I want to sell it. I'm not going to get you consent of other heirs. I'm not getting along with my other heirs. He may not tell you also that he's not getting along. I will not get you consent. How do you protect a purchaser in that scenario?
You can always invite objections, that is the first part. If purchaser's advocate will issue a public notice that my client is willing to purchase this property. If anybody has any rival claim, that is the solution. Otherwise, if we
But
insist.
most of the time, you don't get responses. Public notices are
No,
published
no,
in Free Press Journal, even in Times of India. How many people actually sit and see that there is
Then
property there?
indemnity or the best part, is it, as I told you, even you are exempted from applying for probate. But if any purchaser wants this full security or safeguard his interest, in that event, he will say that you prove before the civil court
Correct.
the execution of will that you are entitled to.
Or seek a
Yeah,
probate,
probate.
an optional.
That is under section 68, even if you file a suit, will have to be proved. Only thing is that civil court will not grant you probate, but civil court will give you a finding that yes, will was executed. And such property is part of the will.
That
That
is
is the
described
highest
in the
one.
purchase.
Or in a given
To
you
take a
can,
risk.
or in a given case, you can take a strategic decision to go for the optional
Yes.
probate application.
You are more safe.
It all depends,
If
it's
it is high stack property, then
correct.
you should not take a chance.
So coming back to our earlier question that since the probate is in rem. Now a situation arises where the executor or a beneficiary earlier was required, executor mainly couldn't act until a probate was issued. There were restrictions also. There are restrictions in the Succession Act that, except for collecting the assets and all, you should not be really distributing the
Correct.
assets or parting with them. Now that there is a repeal of section 213, can the executor do that? Does he need to wait to get confirmation from the other heirs that they are willing to accepting the will and then act, or whether he can go ahead and start?
Strictly speaking, legally, he can go ahead because his rights, to establish his rights, probate is no longer necessary. So he can certainly, in my view, go ahead with the.
But if he doesn't want to take a risk, then he may get
Yeah, so as I said, it becomes a strategic decision. It's not a legal requirement, but still there would be some cases where it is advisable. Where it is advisable that you seek a probate. Where there are large number of properties involved, a large number of illegal heirs maybe, some are not accessible. So in many cases, the legal practitioners will have to take a call on whether in a case like this, it is advisable, though it is not compulsory.
Sometimes what happens, that there are serious allegations against the executor. That is, supporting one party, is not taking proper steps, not distributing, he is transferring some part of it in his own favor.
Correct.
So there may be an application for removal of executor. So to overcome these difficulties, I personally feel, suppose if a professional executor is there, some advocate is there, or somebody, some chartered accountant or company secretary, he should not take a chance because there may be serious consequences against him.
Correct.
If it is found that he is not only removed, but there is some misappropriation by him, then he may be personally liable.
I am with you on this. That it is eminently advisable in a case like this to go for probate.
Therefore, if probate somebody is already filed, he cannot then contend and say, okay, now it is not necessary, I am going to withdraw. If it is converted to a testamentary suit, he should go through the whole.
He should. I think it is more advisable to do so.
I think we have kind of covered these questions, Justice Gupta, but just generally, what precautions do you think that a solicitor, while drafting a will, should take. You said about specimen signature, you said
Correct.
about registration, all.
And Nilesh Bhai came up with this videographing.
Yeah,
idea,
absolutely.
which is a good idea, I should say.
That was, I think, used in that case, I think before you only. The two the firm which fought about their mother's will. I think there was a videographer there. So,
Yes, there was a case before Justice
correct. I
Thankar.
think it was before Justice Thankar. It was entirely.
Yeah, because you see, they must firstly anticipate a third party purchaser's requisitions and accordingly prepare themselves, in my view. So therefore, the signatures, that thing needs to be settled. The disposing state of mind needs to be settled. No, you have to collect as much material as you can. No? That supposing this person is actually doing some important work, even otherwise in life, must collect those instances, must collect that material to show that that person at the time when he made his will was in a perfectly sound disposing state of mind.
So the testator should add an entire preliminary preamble to his
No, not
will.
the testator, but his solicitor should.
No, I agree, but if the testator puts it in saying that I am.
No, that is-
And yes, so and even
It
the
helps.
as I said, the circumstances, if there is any suspicious circumstance, then care must be taken whilst drafting the will to cover
Yes,
that
for
up
example,
to-
I had a case where, out of the children, 3 children, the testator wanted to give it to one child because that testator only had good relations with that one child. The other two are not even taking care of him,
Correct.
never in touch with him. In fact, one of them was harassing.
correct.
So that testator had in fact given me instruction that you write all this down in the will because I want to say the
Correct.
reason why I'm not giving it.
Correct.
So that would be a good way to.
I have one example from my practice days when I had advised a friend's father. And he told me that one of my sons is living in Mumbai. He has a bigger flat. And of course, the Mumbai flat was much more valuable than his Pune flat, which he had other flat. But my other son is living there. So, we wrote in the will. He said, I don't want to disturb their lives. If I do anything otherwise, than giving this flat to the Mumbai son who was living in Mumbai and that flat in Pune to my son living in Pune. And I will also write that to somewhat compensate it, I'm giving even the movables to my son who is living in Pune. Now, this circumstance is fully explained in the will itself.
Correct. But I had a case where there were 4 sons. Mother was living with one son. She left her entire estate to that son. But in her will, she specified that so-and-so son has created this trouble for me after my husband died. So-and-so son has gone and stolen things from my locker. So-and-so son has filed suits against me. I've had to defend myself. This is the decree I've obtained. This, that, that. All of it specified. The will was still shut. We had to lead evidence. We had to go through a whole thing because the thing was suspicious circumstances. It's unnatural for a mother to leave out 3 sons and give it only to one son. And it went into a full trial and it ultimately resulted in a judgment in favor of the will. But these things happen even when you mention. So,
Correct.
No, but these are the precautions. What
Yeah,
I'm trying to say is that these are precautions you must take.
so we have now learned in our drafting.
Correct.
Previously, you say don't
Because
wash
even
your
in
dirty
the case which you mentioned, the most important thing was the last thing that you said, that you succeeded.
Yeah.
Why? Because you took all this
But you
care.
have to go through the pain of
No,
the
but
trial.
therefore, now that we don't have to take probate,
Correct.
it's not
And go through the
compulsory.
pain.
It is better to mention this. That is
Yeah.
what is there.
We have all learned. I've learned from my
Opinion.
litigation to
Correct.
now start putting.
Yes,
Previously,
correct.
I used to advise clients that no, don't wash your dirty linen. Say whatever.
Oh no, all of us do learn.
Okay, now I'll just diverse a little bit because now even with Succession Act, there has been a change in the Cooperative Societies Act where a whole chapter has been introduced
Correct.
relating to cooperative housing societies, and more we are concerned with because there are flats in Bombay, and I think Bombay has this particular, let's say, a situation where normally the societies deal with transfer of shares and flats are transferred by mere change in the share membership,
Right.
which is not elsewhere. Elsewhere, even in there are rights which are transferred, but here mere transfer in the shares it happens. So in 145B13,
154B.
154B13
Correct.
of the Cooperative Societies Act, which was introduced, the words that they have used is testamentary documents, which is not, there is no definition again. Testamentary documents or succession certificate. Now, succession certificate really doesn't apply because it only applies to movables. I don't know how they've used these words. Or legal heirship certificate or document of family arrangement. Now, considering that, since probate is not required, earlier we used to take.
Because the societies did insist on probate.
Yes. They used to insist not only on probate but a deed of transfer also. Now, deed of transfer is nowhere actually provided in law. It was just a formal document.
Correct.
Which was a part of.
It was actually the solicitor's invention.
Yes, I would put it that. But then they started insisting, no, you must still have a deed of transfer.
It's also part of the Stamp Act, which says executor to beneficiaries to 500.
Correct. So that it made sense.
Correct. Now,
you didn't have to incur any cost.
Correct.
In SEBI LODR regulations also, read with the SEBI circular dated 15 September 2016, the procedure of transmission of securities is given. How you transfer securities. Since probate is no longer required, can society or the share transfer agents or companies still insist on probate?
Yeah, this is going to be one area where people are going to face difficulties as we see it quite obviously. But it has a clear answer according to me. In the first place, actually, there was no particular reason why the state should have passed such a law. 154 section 30 regime was perfectly suited, for the situation. Because in any event, the only question was, once there is a nomination and you transfer to a nominee, it gives the society a complete discharge. No heir can claim against the society. But as between heirs, it was always open, and that was a good law on the point. But anyway, since there is a law, we have to live with it. Now, the answer to your question, according to me, it is very clear that a will is nothing but a testamentary document and the society is bound to act on it. In fact, we have a judgment of the Supreme Court in the case of Pavitri Devi versus Darbari Singh, which explains what a testamentary instrument is, and it says a will is a testamentary instrument. If it's a testamentary instrument, it's a testamentary document and it has to be used. In fact, it considers the definitions in the law lexicon. It considers the Black's Law Dictionary. It's a decision, it's an old decision, 1993 by Justice Ramaswamy. I'll just read the portion. Where in Comprehensive Dictionary in International Edition, the meaning of testamentary is stated as derived from or bequeathed by or set forth in a will or appointed by a will, etc., etc. And it then also says in law lexicon, a testamentary instrument was defined to mean one which declares the present will of the maker as to the disposal of his property. And it is nothing but the will of the testator, what we call the last will and testament. And if that is a testamentary instrument, the society is bound to accept that, and minus the compulsory requirements of its probate, the society has to act on such bills. And in any event, it can take adequate protection. It can insist on NOCs by the other legal heirs. It can take an indemnity from the applicant, etc., etc. But it is bound to act according to me. Even otherwise, it is very much advisable that you must include the legatee whom you wish to transfer the property to in your testamentary disposition as a nominee. And even there, we have two recent Bombay High Court judgments. One in the case of the Mahim Makaran Society, and the other of Justice Godse, and the other in the case of Foreshore Cooperative Society by Justice Borkar, where, in fact, in this Foreshore Society's case, the learned judge did say that once the legislature has provided a specific regime for transfer of interest upon the death of a member, coupled with the provision of provisional. Of course, it says if you transfer on this basis, it is provisional. But what he says later is important. It is not open to the society to take shelter behind, because in that case, the society had merely joined the transferee or the nominee as a nominal member. Said you can't do that. And lastly, it says where the nominal member is also the undisputed legal heir of the deceased member, the society is expected to regularize his position in conformity with section 154B30. This is the Foreshore Society judgment. There is the latest judgment of 2025. It is declared on 5th December 2025. So it makes imminent sense for any draftsman or any to include the legatee as a nominee, get it transferred to him, tell the society that there is no rival claimant, there is no case, nothing is filed, even bring the other legal heirs, no objection or whatever, or consent affidavits, and get it transferred. The society is bound to, according to.
I'll just add to what my brother says. On nomination, there are a series of judgments. I also did not work. Nominee does not confer any
Right.
title. So under Cooperative Societies Act as well as bylaws of the societies, at the first instance, society is bound to transfer in the name of nominee if the nomination form is properly registered and taken, registered in the register of nominees. Once that is done, subject to certain undertakings, at the first instance, nominee's name will be, the flat will be transferred in his name, but as a nominal membership will be given. That is what the view taken by Justice Borkar. Justice Borkar also says that whether that person is a title or not, that society can't go into. Society has no power to go into that.
Correct.
The problem arises when at the first instance flat is transferred in favor of nominee in the strength of nomination form. When that nominee wants to sell the property to somebody else, then whether he can sell it simply as a nominee or on the strength of nomination form, he can declare himself and create third party rights in favor of someone. So their societies are insisting in the type of situation that so far so good, on the basis of nominee we have transferred in your favor, but nominee is only a trustee in the records of the society, and ultimately property will be transferred in accordance with the inheritance law applicable to the parties. If that is so, when he applies for transfer, that time society will say that now you produce your title, that you have become owner of this by virtue of some testamentary document, or you bring the consent of all the legal heirs by following the other procedure, they give indemnity, family settlement, the last
Or a
document
release
was-
or whatever.
something.
Correct.
So only on the basis of nominee, I don't think anybody can
Yes.
transfer the property.
In
It
fact,
is only a trustee.
Correct.
in fact,
But-
there that
but
judgment is there of just Indra Vai
Indira Vai, Supreme
of
Court judgment.
Supreme Court, and then which is followed by Justice Oak's judgment in Shakti
That was
Yazdani.
under
Shakti
companies,
Yazdani.
under Companies Act.
under the, no, they have dealt with everything, including the
Correct.
Societies Act.
The
all
Indira
the
Vai's case
nominations.
deals with all this.
Yeah. And Justice
And it also proceeds on the same
bench
footing.
judgment of
That after all, this doesn't determine the question of title, but it is. But now the difficulty is because of section 145, 154B30.
yes. No, but
There you see,
also,
as I said, a will is a testamentary document and they are bound to act.
but that 154B13 also provides that if there is a nominee, then it will be transmitted to him only as a provisional member, as they have defined that.
Correct.
That is there in
Correct.
section.
But the Justice Borkar has gone in foreshore a little ahead, and he says that if there is no contest, then the society at some stage must regularize, because it can't keep it in kind of a limbo.
Like for example, solicitor's role or advocate's role in this type of situation, where nominee, he was to create third party rights, he was to sell. So what do? on the basis of his name being transferred on the strength of giving nominee, can you allow the further transfer of the property without title is vested in according to applicable succession law? So there, of course, you will insist that nominee is not sufficient. You are only a
Right.
trustee. You don't become owner because of
Correct.
nominee. Now, either you bring some probate or letters of administration or
Legal aid
legal
certificate.
certificate or even family arrangement where all
Correct.
Correct.
and that also should not be binding. Some more safeguard should be provided. The indemnity.
Yes, correct. Ideally, that is so.
One doesn't know that there are some more legal aids. They are not part of family.
Correct. But
And what do you do?
yeah, but the main thing is, how is it the society is concerned? That is the main point. When you are transferring it to a nominee, that gives the society a complete discharge
Yes.
against all claimants to the property. Why should they bother about it? If there is somebody who is affected as a result of society allowing that nominee to further transfer the property, then it is for that person to go to a court of law or seek appropriate relief. Why should the society feel that its hands are tied down? No.
The only problem is that immediately the claimant joins the society and drags it to court.
So-
It happened in a case.
It doesn't have to contest that suit. It can
It's
remain a
also-
formal party.
Now situation will take against the securities, the share transfer agent.
Correct.
What happens is the shares are in joint names.
Huh.
Now, as per company law, it gets transferred
To
to
the
the joint holder.
holder, yes.
At the same time, nomination is also provided in a company. So there is a conflict, whether it should be transferred to the nominee or to the joint holder. What the share transfer agents have also been doing is that despite probate of the deceased person being given or succession certificate being given, they will say, no, you still give me affidavit, indemnity, and you go through the entire process of filling all the forms and everything. And I will not transfer till that time. And if there are two joint, then you get probate for both of them. Or sometimes you get for both of them, they say, no, you should have got for only the one who died later. So there is so much of confusion. So now that the requirement of probate is gone,
Correct.
shouldn't they be
Yeah.
acting only on the basis of the will?
Yeah, they should be. And so therefore the fraternity, including all the commercial stakeholders, everyone will have to then now adapt themselves to this new law. There's no doubt about that.
In fact, when probate was also protested, they would say, no, bring an order of the court. So they did not consider probate as an order of the
So
court.
everything depends how
Yeah.
safe you want to be. One society will say, I'm not concerned, probate is not required, I'm transferring.
Correct.
Another will say that Repeal doesn't say that you are not bound to obtain any order to prove your title.
Correct. It is still optional.
Optional.
So we
It is
want
not-
you to exercise that option.
There are other options, if not by through probate, through other civil court
Right.
proceedings. Then it depends
Right.
upon society to society and authority to
Yeah.
authority.
So can they insist that no, you get a legal aid certificate?
If they insist, legally correct. That's all that we can say. Whether they will insist or not, that's a matter of
Saying if they insist.
If they insist, the person can refuse. And if he goes to a court of law, the decision will be in the person's favor. That's all as legal,
I don't
as lawyers or as judges,
And
all that
costs.
we can say is this. We can't speculate what the society is.
Justice Dhanuka, we have already discussed about what executors must do, what beneficiaries must do, what transferees must do. What should lenders do when they are faced with a unprobated will on the basis of which a person claims that I am the owner of the property and I want a loan against it, I'm willing to mortgage.
Lenders have no role according to me. Of course,
Should they accept the
Letters-
unprobated will?
letters of administration and in certain circumstances even credit can apply for the succession. Lender will go by the estate available on the date of death. If something is available, he can make his claim against it. And that also to the extent the beneficiaries get out of the estate. Legal
No,
has no-
that I understand, that they will have a claim on whatever is the estate left. My question to you is, if a beneficiary has inherited property through a will and then goes to a bank and says, I want a loan against this property, then what should the lender do?
As a matter of precaution.
As a matter of precaution,
Precaution against indemnity and all that.
Correct.
There is nothing else.
and then hope that no litigation
Ah,
happens.
Indemnity, you are not, you don't get a chance to apply for enforcement of indemnity
Yeah.
for some period of time.
I think this last question is covered.
This second last 9.
Yeah. So Justice Gupte, in places outside the original jurisdiction of the courts or presidency courts of Bombay, Calcutta and Madras, no probate was required. However, procedure for transfer of properties and assets from deceased or executors to beneficiaries was still being processed without insisting on probate. Now, what would we do?
Yeah,
In
we'll be exactly in the same position as these others were. According to me, it can be done normally on 4 documents. One is, of course, the original will and its copy. The second is death certificate. The third is some sworn statement of the beneficiary that what he produces is indeed the last will and testament. And lastly, an NOC or affidavit of some testimony from the other legal heirs on the basis of this, if at all. Because the registering authority is not deciding the question of title. So on these 4 documents, they must and they are bound, in my opinion, to effect the transmission.
Should one more document be added to that, which is the affidavit of the attesting witness to the will?
Maybe, yeah. Maybe in a case, if he insists on that, he would be within his rights to do so. But besides that, he has no role to play. As the Supreme Court has also said, he is doing it from a fiscal point of view. To see whom should the land revenue be claimed from and all those things. How is he concerned with title? So that's it.
One more question that has come to my mind, which I am going to ask both of you, and you can both consider. That in case of a person who owns, say, a tenanted building or is a lessor of a property, and he dies, leaving a will. And under the will, the beneficiary claims that I am the landlord now, or a lessor now, in place of the testator. Now, probate is not required. So, in case of the tenant or lessee, can they challenge the title and say, no, unless you probate the will or unless you establish your right that you have got under the will or the will is genuine, I'm not going to accept you as a landlord, or you are not the landlord. How can I know that you are the landlord? Maybe some other heirs will come and challenge the will. So how can I take that risk and consider that you are the landlord? Or a case where even, the court, if there is a suit pending against a tenant, and where he goes and makes an application to the court to substitute himself.
Yeah.
Earlier, there was a requirement that he would be substituted, the suit would go through, but the decree would not be passed until probate is obtained. So what would happen in such a situation?
See, according to me, as a very concept, a tenant questioning the landlord's title is quite foreign to the law. Only in a case where there are rival claimants, then of course we have the procedure like of an interpreter suit, which can be filed if he says, I have no dispute with payment of rent, but I must know whom should I pay. Then he can file an interpreter suit where there are rival claimants. But if there are none, then he has no business to question the landlord's title accordingly.
I have some opinion on this. First of all, I agree with my Justice Gupta that tenant cannot question the title of the landlord. The challenge is that eviction decrees as a matter of course. That is one part. But other part, suppose the beneficiary under a will, son of the testator, he files a suit for eviction against the tenant that now I am landlord and you have committed violations of various provisions of rent time. Give me possession. Can tenant say that who are you? I don't know. And then somebody else was my landlord now. You are claiming to be landlord. So in that situation where your title is disputed rightly or wrongly, you can prove your will, execution of will, by the same way what is provided under section 68 of the Evidence Act. That is one. There are series of judgments which say that a piece of this document named as will is only a piece of document unless it is proved in accordance with the court of law, in accordance with law. If that is the situation, I am wondering whether only by virtue of amendment to section 213 goes, what is the effect of that? Can that unproved document becomes an authentic document or proved document and straightway can be used for the enforcement of rights by the beneficiaries under that will? It may be that probate or letter of administration may not be required. That is dispensed with now. But how do you prove whether automatic that document can be enforced if there are rival claims put up by somebody that no, I challenge your entitlement under the will because will is not proved. So merely because probate is dispensed with or letter of administration is dispensed with, there are other proceedings. It is optional. You don't go for that. You can still go for, but you don't want to go for. And in this type of situation where there are collateral proceedings, where somebody is challenging your title, you will have to prove the execution of will. The execution of will is proved, then automatically everything follows. Because then you can say that tenant has no business to challenge my title, he should be evicted. The execution in any case will have to be proved.
But then
That
for
is one-
execution, one will have to file a separate civil suit. Can't be done in the rent court.
A declaratory suit can be filed.
Because
The
that
rent
issue has
court will not have jurisdiction.
because that issue has arisen about maintainability of suit. If that is so, then in that court you can need evidence that yes, will was executed.
Will the-
Otherwise, in civil court, you will have to
Yeah.
file independently that I am claiming my ownership. It may be declared that plaintiff has become owner by virtue of execution of will. So in that question, their question will arise, court will say that all right, you prove this, other side is disputing your.
Will the court have jurisdiction?
But still the point is,
Decide that.
the tenant won't be within his rights to do so. That's the point.
Yes,
Because he cannot question this unless there are rival claimants. But the landlord can always say, if I want to stay clear of all this, and I will prove, because that's how classically a suit for declaratory is filed. When someone is interested in denying your title or your character, then you go to a court of law and seek a declaration.
Civil court has power to go into
That the
the
court always
execution
has the
of will.
power to do so.
Civil court will not grant you probate or letters of.
Correct.
District court, yes. Civil court, no. So this is one of the issue which will have to be gone into.
We have just a couple of questions.
Yes.
One of our members has asked,
Yes.
what happens in the case for joint will where one party has passed away and already filed a probate? Does the executor have to file a probate application after the demise of the remaining spouse?
No,
So one-
Dhanuka and myself, I think we will differ on this. Because in my opinion, I have already said so earlier that when this spouse dies, the law no longer requires a probate. And therefore, there is no question of compulsory application for probate. As a matter of strategy, the executor may or may not decide. Because as we said, it depends on various things, you know.
I agree that if this has happened after the amendment,
If the second spouse has died after that.
after the amendment, then of course it is not compulsory, it is optional. But ultimately it is one single document and where
Correct.
probate is already filed. We must pursue the same thing by amendment or file a separate petition and take it together and prove it.
Right. There is one more, section 213. There are many, but I think lots of them cover the issues that we have. Section 213 instead of main provision has become exemption provision except for 3 cities. Sites still compulsory. 214 probate is still compulsory for deaths. Therefore, it applies to whole India. Section 227 is now the main provision in absence of exemption of 213. 227 applies to the whole of India. What is your view?
Correct.
7 of course.
No, and 214 has to be, according to me, the legislature must step in. This is a lacuna. They must,
All covered.
yeah, that is already covered. But this 227 we have not still considered.
227 says
But
that
the effect of
effect of probate. Exactly.
Correct.
So if probate is not obtained, then some other proceedings.
The effect of
or since the probate is an optional thing, whenever it is obtained, it has this effect which is provided under 227. But that does not mean that this effect cannot be had in some other way.
No, what I think they are trying to ask a question is that now that the probate is not required, will the will by itself have effect throughout
Correct.
India? That's what would be their question.
Yes, it would be.
Under 227. I think the will would have effect all through the world.
Correct.
Because that is merely an intention of the testator.
Yeah.
The genuinity if wants
Just
to,
as wills executed otherwise than in the three presidencies always had this effect. The wills executed in the three presidencies hereafter, after 19 December, not wills executed, but their effect after 19 December 2025 will be just the same.
There's
That's
one more
my-
interesting question. Will this lead to flooding of litigation in the court from probate bench?
Again, speculation. We don't know.
I think we had a very
You have
interesting
option, either you file
discussion.
probate petition or you file testamentary suit or civil suit for proving a will. And side by side in the same, you can apply for
It's
declaration of the
Correct.
title.
It's faster to
But
file a
in any
probate
event,
petition than filing a-
But in any event, you must consult a legal professional.
Oh, you've got us lots of work.
Not a chartered accountant or other profession.
I know.
Some of the clerks practicing only in probate matters will be seriously affected by this.
True.
So just to conclude, what this section repealment of section 213 is prospective in effect.
Right.
So anything you need to do after that, it will not apply. I mean, you don't have to go for probate, even if a person has died before, left a will before, and you have not applied for probate earlier, you need not apply again.
That's
Unless,
a vexed question, as
Ah.
they both have a referring view on it.
yeah,
Right.
so that is Justice Gupte's view, and
Yes.
Justice Dhanuka says no.
It
If a
applies for
person
date of
has,
death.
it will apply if a person has died earlier.
Correct.
And but it would always be better to go and apply for probate. It is also
As a matter of strategy,
At the
it could be a
strategy, it is better to go and apply for probate. Particularly if you feel that there is going to be a contest or something, it is best. And also executors who are independent executors,
correct professionals.
professionals or heirs are not the executors, and there are so many beneficiaries there to whom person has given a will. Then it is better that it is prudent that they apply for probate, even if it is repeal. And at the same time, the authorities or societies or they cannot insist that no, you must get a probate because now it is not.
Correct.
Will cannot be elevated to the status of a decree. Will is will ultimately. It is false, it is fabricated, it is genuine, one doesn't know. So before giving effect to the will, how much safeguard you want to take, whether you insist for some court order for giving enforcement or you accept it, will is there, so it must be genuine. That is my view.
Because if you go to a civil court, it's going to take years with the delay in litigation.
That's why it's faster to
Ah.
file a probate petition than go to a civil
Ah.
court.
Yes.
This
Which
optional
anyway is an option.
Option.
I think we've had a very fruitful discussion. You've given us lots of ideas.
Thank you. Thank you.
We have learned judgments which otherwise
Yes.
you would not have.
And I'm sure lawyers are going to think of many more ideas.
So the request would also be from our members to share those judgments. So can we share those?
Yeah, sure.
The
We can do
ones you
so.
have quoted.
Yeah. Of course, we can do so.
So we'll then share it later for the benefit of our members.
Right.
Thank you so much for spending
Thank you.
time, sparing time
On a
and
Saturday
coming on a Saturday afternoon
more
for
than
us.
It
And
was
our
a pleasure
members.
and it's an important issue.
Same here.
The profession is concerned and it's I mean an honor to be part of this kind of a debate.
And views from experienced persons is the best that we can get.
Absolutely.
No,
Thank you.
ideas,
Thank you.
you say ideas will be more and more clear because this amendment has come. So there will be hundreds of disputes arising out of this.
True.
So. as
But
a
it
just-
will, I
brother
think,
is
evolve
alive, so I
later
am
like
very
everywhere
generally
else.
the court.
Some simplification in.
Mediations.
Thank you, everybody.
Thank you so
Thank you
much.
very much.
Thank you for joining, everyone.
Thank you.
You know,